So when we talk about estate planning, people very understandably get confused about what we're even talking about because there's living wills, living trusts, and they're like, I don't know what does what. So let's kind of break that down a little bit. When people hear power of attorney, there's two different types of power of attorney documents, especially specifically in the state of Georgia. So in the state of Georgia, we have the Georgia Durable Power of Attorney, and then we have the Georgia Advanced Healthcare Directive. And both of these would be considered power of attorney documents. One is healthcare, one is financial. So one of them is if you are alive but incapacitated, who do you want to access your bank accounts, pay your bills, keep your life running, in the event that, again, you are alive but incapacitated? The other one is if you're alive but incapacitated, who do you want making your healthcare decisions for you? What do you want to happen at the very end stages of your life? So the Georgia Advanced Healthcare Directive actually is two things. It's your healthcare power of attorney document, and then it is also your Advanced Healthcare Directive, otherwise known as a living will. So again, it says, okay, these are the people that I want making medical decisions for me, and then here's what I want to happen at the very end stages of my life. So oftentimes, when we're talking about the financial power of attorney and the healthcare power of attorney, we're not necessarily talking about the same agents. The person that you want paying your bills and accessing your bank accounts may be a completely different person than the person that you need making life or death decisions for you. Please remember, for the healthcare power of attorney, we do not want to name someone that is emotional. So even if your daughter is your best friend and she takes you to all your healthcare appointments, if she's not going to be able to make the decision about whether mommy or daddy have the plug pulled or not, she's probably not the right person. It's honestly mean because she could actually develop PTSD. So back to the topic, power of attorney documents, what do they do and what do they not do? So a lot of people think that if they have a financial power of attorney document for their parents, that this fixes everything, that it applies even after their parents pass away. That is wrong. After your parent passes away, that document does nothing. Now it's either the will or the revocable living trust that are going to control what happens to the assets. The financial durable power of attorney is only valid as long as the person is still alive. Now, the healthcare directive does have a couple of after death decisions, like can the healthcare agent get an autopsy? Can the body be donated for medical research? The organs donated? What do you want buried or cremated? But other than that, the same thing applies. It only applies while you are still alive, not after you've passed away. So, durable power of attorneys, very helpful. Obviously, way better than nothing because guardianship or conservatorship is awful process that we do not want people to have to go through. It's very expensive and time consuming. So having a Georgia durable power of attorney and healthcare power of attorney is so important. But they only apply during incapacity while you're still alive. They do not apply after death. And oftentimes financial institutions don't like working with them. So they're not always as effective as we would want them to be. Because the big banks, Truist, Chase, Capital One, they don't like working with those documents. It's a liability for them. So even if you are validly incapacitated and the person you've named as your power of attorney agent tries to go to the bank to access the money to pay your bills, they're going to run into roadblocks. So right now I have some clients whose mother very clearly told her financial advisor that she wants to make a gift to her kids. This is very common. I highly promote it if it makes sense for your family to go ahead and give some money while you're still alive. The mother is old, but she has a significant estate and it's not going to be an issue. She has plenty of money to take care of her. They're not gifting away all the money. They even have a power of attorney document for their mother. The financial advisor has sent them to legal compliance because he said that they're trying to take advantage of the elderly. However, first of all, she made this decision and she told him she wanted to happen, and they have power of attorney. So why can't they just do this based on the power of attorney document? Because it is still a limited document. And again, financial institutions are not going to want to rely on this document. So that is why revocable living trust can be handy even in incapacity circumstances. Instead of my clients having to rely on just a durable financial power of attorney, instead their incapacity trustee can step in. It waives liability for the financial institution and makes it a lot easier. So those same banks, Chase, Capital One, that don't want to work with financial power of attorneys also probably don't want to work with living trusts. So we're going to run into a little roadblock there. So that's when I say maybe consider moving some of your assets to a more local bank. Or if you have a financial advisor, let's look at your investment accounts and maybe move those over into the trust. So there's lots of flexibility. But all that to say, durable power of attorneys are very important because you do not want your kids to have to go through guardianship or conservatorship for you. But they are limited. They do not have any impact after you pass away. And even while you're still alive, some financial institutions do not want to work with them. So instead, we can have a revocable living trust where your agent has double power. Power via the power of attorney and power via incapacity trustee in your trust. This waives the financial institution of liability, makes it a lot easier for them to step in and take care of you, and it protects from elder abuse. So there's lots of different ways that we can protect you during incapacity. There's lots of different documents in estate planning that may or may not apply to you. So that's why it's really important to meet with a professional that specializes in estate planning to make sure that everything is set up properly for you.